Karen will read the opening statement.
All righty, so we'll call the meeting to order, the Princeton Zoning Board. This is a special meeting of the Princeton Zoning Board of Adjustment being held electronically via Zoom on July 16, 2025 at 7:30 p.m. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the sunshine notice of the Princeton Zoning Board of Adjustment. Such notice has been placed on the official bulletin board at the Princeton Municipal Complex and by transmitting a copy of the notice to the Princeton Packet, Town Topics, the Times, the Trentonian, and by filing a copy with the clerk of Princeton on July 1st, 2025, and has been posted to the municipal website. Pursuant to Executive Order 107, due to the state of emergency in New Jersey regarding COVID-19 coronavirus, notice that during the declared state of emergency, all regular and special meetings of the Princeton Zoning Board of Adjustment will be held electronically via Zoom, was transmitted to the Princeton Packet, Town Topics, and the Times, and was filed with the clerk of Princeton on the 24th day of April, 2020. Such notices were also placed on the official bulletin board at the Princeton Municipal Complex and on the Princeton website, and are to be maintained throughout the year and by transmitting a copy of same to the Princeton Packet, Town Topics, the Times, the Trentonian, Comcast Media, and by filing a copy thereof with the clerk of Princeton. Notices have also been placed on all window doors of the municipal complex.
Okay, Claudia, can you call the roll, please?
Ms. Chen,
Here.
Ms. Coulson,
Here.
Mr. Floyd,
Here.
Mr. Shriver,
Here.
Mr. Tenenbaum,
Here.
Mr. Stein,
Here.
Ms. Donna,
Yes.
Mr. Dobkin,
Here.
Chairman Cohen.
Here.
Thank you.
You're welcome. All right, we have one application this evening. This is a continuation. It's ZBA case number Z24-515. The address is 347 and 372 Ridgeview Road. Excuse me, block 401, lot 13 and 14 of the RA and RB zone. So Karen, Derek, Karen, are the applicants here this evening?
They have, I see Mr. Schatzman. I think he's with his engineer, David Schmidt. I think I see Mr. Schmidt in the background there. Board members, I don't know at this point if I know staff has some questions or whether you want to begin with that or whether you want to begin with Mr. Schatzman giving you a recap.
I'll do some housekeeping, okay? I sent you, Miss Casey, 2 emails. One on July 9th and one on July 14th.
Yes.
And I like that to be part of the record as A2 and A3. Okay, because they have proofs, to my mind, for this application to move forward, okay?
Is that something that you're going to present tonight?
Well, they're letters, and I'll just summarize the letters.
Okay, but the proofs, did that go to the
The proofs are, the staff wanted a proofs of Mr. Keller Senior's business as a plumber in the subject property since 1953. And I sent to you, I sent to Derek Bridger. I don't know whether he sent it to the board, of all sorts of income bills that Mr. Keller Senior sent back in the 50s and the 60s and the 70s, an income tax return showing him as a plumber back in the 70s, also permits that he got, plumbing permits he got it from the then Township of Princeton for for his plumbing business. And then I wrote you a letter regarding estoppel in the Jantush case. I cited that. And I cited the bridge case and the other case, the Holman case that sort of added to the what the test was for the Jantush case. Is our contention that that it's a non-conforming use. And since it started in 1953, it's also latches. And that was of concern to the staff. And on May 28th, a concern to the board. However, as we go forward, I'll modify our position on that, and we'll take it from there. Mr. Keller, you asked in one of your email on July 9th, you asked if the board were to give Mr. Keller a use variance, would he say, would he limit it as to the time? And I've talked to Mr. Keller is here, and am I right, Mr. Keller, the maximum you would continue on with your business there is 10 years. He's 60 years old now. And 70, I'm sorry, 70 years old. And, you know, he's going to quit on or before he reaches the age of 80. So you get rid of a non-conforming use once and for all. And that's what he would prefer. That's what I think we ought to do in this case if you're willing to give him a use variance. Dave Schmidt was asked by Mr. Wiseman and Mr. Bridger of the FAR, and you figured out the FAR on lot 13, did you, David? You recall Mr. Schmidt is the engineer who was previously sworn?
Yeah, I did the calculations. We're currently, it's on the plans on the bottom right-hand corner is the FAR for lot 13 is currently 3.84. We add the extra 1,000 square feet for the upstairs apartment, and that takes 60/50. It gives you an FAR of 4.6. The maximum allowed is 7.5, so we're well below the FAR calculations or requirements, so we don't need to seek an additional variance for any FAR. And this was a very conservative number for the existing house. I'm using the outer footprint for the first floor as well as just doubling for the second floor. So it's a very conservative number for 4.6.
Excuse me, please. I have a couple of questions just on process here. I thought we were going to start differently than this, and I actually thought whenever, maybe it's not true, but I thought we would need to have people sworn in if they started speaking tonight. Or
Well,
just
actually, if I
last
do consider,
carry over.
no, I do consider Mr. Schmidt still under oath, and I thought, Mr. Schatzman, you referenced that when he started speaking, that he's still under oath. So absolutely, if we have anybody new testifying tonight, we will put them under oath. Mr. Schmidt previously testified, so I do consider him still under oath as this hearing is continuing.
That's correct.
Mr. Schmidt.
So where are we in the process right now, though? We're just jumping in to where we left.
We had the meeting on May 28th. You listened to the tapes. We had the planner, and he's still.
I was at the meeting live. Yeah.
Oh, so the planner's here, but he gave his testimony to special reasons, in particular suitability. He gave the lack of the negative criteria. We went over some of the issues, and I want to just continue on the resolution of those issues tonight.
Mr. Schatzman, I have, as you said, a housekeeping issue for you. During the first hearing, I'm looking through my notes. What exhibit did you put in as exhibit A1? Because I'm not aware of, at least I don't see it in my notes.
What were you saying?
I'm saying, at the May 28th hearing, did you admit any exhibits at that hearing?
Did I admit,
Exhibits,
Yes, A1
which was, what was
from the
it?
plan, from the planner who showed you the pictures of the property, all sorts of different pictures.
Okay. And now exhibit A2, you want that to be the proofs, the letter that you
A2, I
sent me?
want it to be the answer that you sent, the email that you said that the staff wanted to know, besides the testimony of Mr. Keller Jr., do you have any proof that Mr.
Right.
Keller Senior was operating a plumbing business on the property? And
Correct.
on July 14th, I sent you an email giving you all the different, I'm sorry, it was July 9th, all the different permits and proofs that I believe establishes a non-conforming use. So, and then I gave you a letter regarding the Jantush case.
Yes, yes.
July 9th letter, I gave you my argument with the Jantush case
Right.
versus Verona, Estoppel. I gave you the bridge case, which was an ancillary case to that. I gave you the case of Allen versus Freehold, which is an ancillary to that. I quoted the ordinance that was in effect in 1938 in Princeton about what a home occupation was. And I told you, in my opinion, the definition included a plumbing business, and the way it was worded, I said it was justum generis, and it wasn't expressio unius. That's the way you can, as you well know as a lawyer, that's the way you interpret statutes and ordinances as a doctrine, and that's what I said.
Mr. Schatzman, do you want to share those proofs with the board? Can you share your screen so they can see that, if that's what you're going to rely on tonight?
What do you want? What do you want to share what?
Those proofs, the documents that you submitted, you gave me a copy. Did you give a copy to the board secretary?
Yes, I did.
You did, all right. Claudia, do you have those?
Claudia, you're muted.
I gave them to Derek Bridger,
Mhm.
and I copied Dan Weissman. And I assume that they sent them to people. I don't know the addresses of the people of the board. I just assume that.
No, but ordinarily, if you want an exhibit submitted, then you would submit it to the board secretary as an exhibit,
did.
so. Okay.
I
Claudia-
have 1, 2, 3, 4, 5, 4 pictures.
All right, that was the exhibit from the
Exhibit
first
A1.
hearing,
Yes,
yeah.
correct.
But did you get anything from Mr. Schatzman, these proofs? They look, what how they look like receipts or old permits. So did you get copies of any of that?
I have his letter from July 9,
Okay,
and that has, that does have like a plumbing permit from
Yep.
1956.
okay. All right, well, Mr. Schatzman, Mr. Schmidt, does somebody want to share their screen so the board can see that? Or, I mean, I'll leave it up to you how you want to handle your presentation, but
Can you put this on the screen?
I see if she has them, if Claudia has them right at her fingertips, that'd be great. I don't have them.
I sent them to Derek Bridger.
Yeah, we have them. We'll try to get them up, Richard. I'm sorry.
What's that?
We have them. We will try to get them. We'll try to screen share 'em.
Derek, I have them. Do you want me to pull them up?
Sure. Thank you, Justin.
Mr. Schatzman, I believe this is the letter that you were referring to.
Yes.
okay.
And
So, Mr. Schatzman, your argument is, as you set forth in this letter, that you believe the plumbing business qualified as a home occupation,
That's right, and
relying on
Because
this,
because of John Tisch versus Verona. And it's gone on for 73 years, doctrine of laches and the doctrine of estoppel. It cannot be terminated unless the applicant, Mr. Keller Jr., terminates it, but he said that if a use variance were granted, he'll terminate it in 10 years. He doesn't want to continue on with his business. He said he's 70 years old and he's not going to sell the plumbing business. He's going to terminate it and just live in the garage, on top of the garage, till he moves or passes on. That's what he said.
so for the board's benefit, this letter is on the screen, and what it references is the definition of home occupation as it appeared in the town zoning ordinance from 1938, and that ordinance stayed in effect until 1955. Then the ordinances were updated. You'll see the definition: customary home occupations such as dressmaking, hairdressing, manicuring, home cooking, millinery, laundry, cleaning, pressing of wearing apparel, in which only members of the immediate family are engaged, provided there is no display or advertising visible from the outside, and the floor area space assigned to such use is not in excess of 20% of the grand area occupied by the principal building. So whoever's screening this, can we move forward now? Okay. So then you had some legal arguments in here, and then you've also argued the town's equitably stopped from preventing this use from continuing. Let's keep going. Okay, let's keep going. Okay. Then you indicate that if the board were prepared to grant a use variance, not find it a continuation of a non-conforming use, but a use variance, that Mr. Keller simply wanted to finish up running his business, and you've confirmed that tonight, saying that no more than an additional 10-year extension. And then if you could continue, Claudia, to what's attached to it now, so the board can see these proofs. Okay, we'll see. All right. So this looks like a permit pulled by Mr. Keller as plumber for a job in 1956, 1957. I don't see Mr. Keller's place of business on that, but these all appear to be permits that he pulled. And if we keep going, 1960, looks like plumbing supplies. This receipt does have Ridgeview Road as the entity, the location of the entity. I don't know if there's any more. Okay, we have another receipt, Ridgeview Road for plumbing supplies. Also plumbing supplies, and these dates are varying in the 50s. Keep going. 60, 59, 60, 63. And then it looks like a tax return for Mr. Keller Sr. dated 1971. Shows Ridgeview Road, and it indicates that he is in the plumbing profession.
The testimony on the May 28th meeting was by Mr. Keller Jr., who testified the business was in 1953 on, And the email, this is an answer to the email that said that you sent to me that the staff wanted some sort of proof
Yes,
other than testimony that Mr.
Correct.
Keller was doing a plumbing business at his Ridgeview Road property during this time. So that's what I sent you. And
okay,
I took the liberty to give you what my argument would be based upon these proofs and the testimony and for the board's consideration. And I said it's an estoppel under Jantich, the Bridge case, and the Howland case. Now you know the cases as well as I do. You can give your opinion to the board. And now tonight, because of your subsequent email on July 14th, I said, if you gave us a use variance, he would not do any more business for a maximum of 10 years. He would quit. He's 70 and he would not do any more business there, plumbing business. So after 73 years, you're finally going to get rid of what I contend to be a non-conforming use, as well
and
as the application of making two conforming lots, getting rid of 3 houses on lot 14. The houses would be 369 and 371 would be demolished. I think we covered that in the May 28th meeting. And so 355 stands. We would post performance bonds for the demolition of 369 and 371. The reason why we're getting rid of 371 is because Derek Bridger and Dan Wiseman did their homework and said, wait a second, when he built all those houses, he was supposed to get rid of 371. And I believe Mr. Keller Jr. testified his father got sick and got extensions, but never attended to any further extensions. So now we're finally going to knock down 371, which should have been done years ago, but Mr. Keller Sr. got sick. Mr. Keller Jr. didn't know anything about it. So we're going to post performance bonds. In other words, we're going to put our money where our mouth is and get rid of those. So there'll be 355, and be converted to a single family dwelling on lot 14. And on lot 13 is 347, which is rented out, was only one single family dwelling. But the 347 on lot 13 is too big for Mr. Keller to live. So that's why we're asking for the conversion of his garage on the top floor to a 1,000 square foot apartment, 2-bedroom apartment with storage underneath for his business to be stopped on or before 10 years if approval is granted, and that's it. So if a use variance is granted, you get rid of 2 non-conforming lots, you get rid of non-conforming uses, and you have a rental on 347 on lot 13. That's the people there have been there for years, and they live there on Ridgeview Road. And Mr. Keller can continue on for his business. As I said in my later email, after you send another email to me, so he can wrap up his business in 10 years, within 10 years, and stay on top of a garage into an apartment with 1,000 square feet, so he can live there and spend the rest of his life there. That's what would happen. So the use variance would get rid of, again, a non-conforming use, which is any planner can tell you, is a goal of planning by any municipality to get rid of a non-conforming use. So that's where we are. And Mr. Keller says, again, for emphasis, that he will not continue on his business for another 10 years.
Oh.
So that's the case.
alrighty. I do have an opinion about whether this is a prior non-conforming use, but I think before we get into that, does staff have questions that they would like to ask? Because my understanding is they may have some questions for clarification.
Yes, I do, Karen and Mr. Chair. I might have missed it, but what is the plan for the house at 369 Ridgeview Road?
Single.
We're knocking that down.
Okay, and will that be under the performance bond as well?
Yes,
Okay, thank you,
I told you we're putting our money where our mouth is.
thank you. And then the garage space, so is the 1,000 square feet the totality of the upper floor?
That's what we're asking for, yeah.
No, it's not.
Well, no, it's more, but the living quarters is, what is it gonna be?
It's about 1,200 square feet. up
Just-
Mr.
Well,
Keller, are you
we're-
testifying? Mr. Keller, it's hard to hear you. Are you gonna testify or?
I have to get up a little closer.
Okay, and you're still under oath. We swore you in last time,
Yes.
so.
The-
Okay.
Partition there.
All the total area up there was about 1,200 square feet. And it was just recommended that we ask for 1,000 square feet, instead of asking for the 1,200. So that's why we're asking for the 1,000.
Okay, that may have been before when you were asking for kind of thinking of it as an accessory dwelling unit. Now that you're asking for that as a secondary primary residence, or secondary principal residence, I should say, it very well might make more sense to just ask for that whole space. Because otherwise it's kind of going to be left unclear what's going on with those extra 200 square feet.
Well, if you want to do it that way, I told him to get it close to 800 as possible. If you want to make it 1,200 feet, we have no,
No problem.
no problem with that. It's up to the board. But I try to lessen the extent of the variance. And you have to understand, I've been doing this for 57 years. I try to lessen the variance from 800 to 1,000 instead of the 800 to 1,200. But yes, if you want to make it 1,200, fine. It's not going to be any more.
Okay,
It'll be
it's
up-
ultimately
it'll be up to the board- it'll be up to the board to decide that.
And from my point of view, it'd be preferable because then we don't have to fool with how to conform it to 1,000.
then we also don't have the question of if that 200 square feet is being used for the plumbing business in the garage below it. It's kind of going to become first floor plumbing business for the next 10 years, second floor residential.
Yes.
Okay, thank you. I don't have any further questions at this time.
Thank you. Anyone else? Mr. Weissman, do you want to testify?
Yes, please. I do have one question. Thank you,
Ben,
Mr.
I don't know
Chairman.
if we swore you in at the last hearing, so let me just swear you in now. Do you swear affirm your testimony this evening will be truthful?
I do.
Thank you.
And if I was sworn in last time, I double swear tonight.
Okay, very
For the conversion space from the multifamily to the single family, do you intend to also provide a bond for that work? And what is the expected time frame for that conversion?
There's no bond for that. No. No, it's no bond. It's a house.
I don't know what conversion would need to be done exactly.
Okay, I mean, we don't know what conversion needs to be done either. Clearly, it's turned into 3 units from a single family, and without knowing what work has to be done, just would be helpful, I think, for the board to understand what the time frame is and exactly what would have to be done to convert that to a single family.
So at the time this work was done in 1974, whoever my father talked to at Princeton Township said that at that time, houses were allowed to have an apartment and also allowed to have a flat. So that's what each one were designated. The rooms were already there, the bathrooms were already there. So the only thing that was added to those that would have to be removed was a small kitchen area, and that could be very easily done. It's not a problem at all to do that.
When would you intend to do that?
So I can do it as soon as the tenants are out. I mean, it's not a lot of work to do it.
Does it
Okay.
function? I mean, are there 3 kitchens in the property?
Yes,
So you'd have to remove 2 kitchens, and obviously there must be partition walls dividing up the space to 3 individual apartments.
About which house?
355.
Yeah.
I'm sorry, I missed what the question was.
Sorry, I'm just trying to, so there are 3 kitchens, you'd have to remove 2, and then I'm assuming there's demising walls within the house to divide it into 3 apartments. It would have to function as a single house, so you could be able to walk through the house pretty much unimpeded, you know?
So the existing internal staircase for, the second floor apartment above the garage is still there. So it just isn't utilized by the tenant. So there would be
Okay.
nothing to do to take that area. It's a studio apartment. So it's a large
Okay.
apartment up there with a bathroom and a little kitchenette area. So that's very simple. The downstairs one, the access was always to that area from the outside. It was originally planned that it was gonna be for some other use. So that one would be more difficult. It would just be that the outside area would remain there. But we could work with whoever wanted to see it or however we would do it. Certainly, it's something that could be accomplished.
Okay, and maybe once, a little later on, we can get, like, as Dan, we do need to have some kind of time frame. But we'll get to that later. I was just trying to get an idea of the complexity of the change.
I don't see that those 2 things are difficult to do at all.
Okay, thank you, sir.
Is the hesitancy to include that under the bond then because it might not happen, or what's the hesitancy?
How's it do? He's got to do everything before you sign the subdivision plans.
Okay,
That gives us a time frame.
Well,
190 days.
The subdivision plans are 190 days,
Yeah.
and he would have to get an extension, so that's municipal land use law, so I mean, it's 190 days, you can live with 100, beyond.
Well, we would do it as soon as the tenants are out, and we expect the tenants will be out. The latest ones will be in mid-September. And then the tenants will be gone, and then the work can be accomplished.
So we're only talking about 2 months. From 190 days to about 6 months, so.
Goes
in the
quick.
end, 190 days. That's the
Okay.
time frame. You want a time frame, that's the time frame.
Thank
Got
you.
it. Thank you.
And you would just have to let me know who's gonna be my point to contact to come up to verify that the work has been done.
We can do that.
Okay.
board members, Mr. Schatzman has suggested that I give you my opinion on his argument that this is a prior non-conforming use. I had an opportunity to speak with Mr. Bridger, and I think he is in agreement with me that I don't think the plumbing use from the beginning would be considered a home occupation. And I appreciate that the definition is not very precise, but it does indicate that only immediate family members are to be employed by that business. My understanding from Mr. Keller's earlier testimony was that his father had about 20 employees when his business was at its height.
Excuse me, Karen, one
Yep.
second. I'm just gonna go off screen.
Okay.
I can still hear, but I won't be visible for 2 minutes.
Okay, no problem. So that does not seem to me to meet the definition of a home occupation. Now, that doesn't mean though that use was not going on for a very long time at that site, but not as a permitted use. So I had inquired of Mr. Schatzman if the board were willing to consider a use variance. And by that, we're not saying that it was previously permitted, but it recognizes it's been there a very long time. what was his client's position then on a time frame? Because ordinarily a use variance does run with the land, but if the applicant wishes to limit that, then that's something the board can consider. So that's why Mr. Schatzman made that reference saying he was responding to my inquiry, and that's correct. So at this juncture, what you have in front of you, and we still have public comment, of course, but what you have in front of you then is a use variance to allow 2 primary dwellings. That's on lot 13, because it already has a single family home. And now, which I understand is being rented. And Mr. Keller wants to turn the second story of the existing detached garage into a dwelling unit that he can reside in. In addition, in order to continue that plumbing business, he would need a use variance, which he's advised he's willing to limit to no more than 10 years. And my understanding that would also have to be based on the fact that he owns it and that he's actively running his plumbing business and that he's also residing there. So as long as those criteria stayed in place and it wasn't more than 10 years, then at the end of that period, that use would cease. It would not continue to run with the property. And then on the adjacent lot, right now there are 3 residential structures. 2 will be demolished with bonding, and the third is multifamily, and that needs to be converted back to a single family. So those do not need variance relief, but as staff has raised the question of potentially making sure a bond covers everything. And Mr. Schatzman's responded saying, well, these would all be conditions for that subdivision approval. So until such time as they were done, the subdivision deed or plan would not be signed off by the board. And the board, under the MLU, has time periods to do this, so 190 days. The applicant can ask for an extension. They're allowed to do that. So they might have to extend the time because Mr. Keller has indicated he has tenants that have to be removed before buildings can be demolished or converted. So at this point, perhaps we could listen to public comment unless the board has questions that they'd like to raise.
An argument against your argument. It's irrelevant with what the zoning officer now thinks. The fact that, that the Jantich case says, if there was a color, if the then officer who gave the zoning permit, if in fact there were a zoning permit, because you have to realize the Planning Act, which is the predecessor to the municipal land use law, was only adopted in 1952. If he thought that it was a home occupation, he gave Mr. Keller Sr. the right to run his business there, and 73 years have passed. The Jantich case applies. It's not whether Mr. Bridger thinks it was a home occupation. This is what the cases say. The other 2 cases I cited for you, the Bridge case and the Howland case, is what the man or woman or whoever gave him the right at that time to do it, and he's been doing it for 73 years. That is Jantich versus Morona. It doesn't make any difference what Mr. Bridger says. As a matter of fact, on the Lanning Plumbing in Montgomery Township, your other municipal land use board, they say plumbing is a home occupation. Also, I had the liberty of speaking with Frank Slimak, who's the predecessor to Mr. Bridger, and just so I'm not, so I'm disclosing everybody, his daughter-in-law is my legal assistant. He told me, as far as he's concerned, it's a home occupation, and in fact, he did it in the borough before you got involved, Mr. Bridger. So the reasonable minds can differ. I don't dispute your opinion, but what I'm saying is, based upon the Jantich case and the Bridge and the Howland case, it doesn't make any difference what Mr. Bridger thinks. It's what the person at the time in charge of zoning, whoever he or she may be, thought it was a home occupation, gave Mr. Keller Senior the right to run his business there, and it's been run there for 73 years. And there's also the doctrine of latches. 73 years is a hell of a long time to be running a business and continuing on. However, as I said, he doesn't want to continue his business anymore. He wants to get rid of it in 10 years. He just wants to finish it up. As I said in my July 14th email, he wants to give it up. And so that you get rid, finally, of what I consider to be ostensibly a home occupation and a stop law. You know, so it'd be a shame for somebody to stop the business after 73 years of working with his father. He and his father alone, he took over in 1987. All he wants to do is just continue on with his business, live on a 1,200 or 1,000 square foot apartment on top of a garage, and spend his rest of his life there. And that's all we're asking. Plus, the town gets rid of that home occupation, ostensibly, gets rid of gets two conforming lots, and gets rid of non-conforming uses on lot 13 and lot 14. So that's it. That's what you have to consider. You take it from there.
I actually thought I heard Miss Casey say that she didn't think of it as a home occupation.
I did say that, even honestly, there's no record that the applicant has produced or that could be located giving any kind of a permit to conduct the business. I recognize it's been there a long time, and that's why I inquired of Mr. Schatzman if the board were willing to give a use variance. Well, what would his client's position be? But so there is no record. We have Mr. Keller Jr., who said he recalled his father telling him that he had approval to run this business, but unfortunately, Mr. Keller Sr. is not available since he's passed. He can't testify to that either. So I think at this point, you've heard from me, you've heard from Mr. Schatzman. If the staff or the board doesn't have any questions, perhaps trying to see, I think we do have members.
I have one question.
Yep.
Just to clarify, so if we're not talking about the definition of the types of occupations, doesn't from what you're saying, the fact that he had around 20 employees, doesn't that alone make it not a conforming home occupation?
Well, that's my approach to it. That's my belief, that a business that size could not meet that definition of a home occupation. So that doesn't mean that it hasn't been operating for a very long time.
Right.
Yes, the receipts indicated that there was a business on Ridgeview Road, or at least that was his address. So honestly, I don't think the issue is really has it been operating there? Because I think between the testimony of the applicant and, you know, those permits that were pulled, they are not every year, but they do run a period of time. But that was my reasoning, Bernice.
Okay, thank you.
I don't see how. So,
And I would think when the business first started, when its doors opened, that it probably wasn't 20 people, that it grew over the years. And the original, there was an original, even though we don't see it, he had the ability to operate that business from 1938. And so I don't see any problem in continuing the use.
well, I mean, Steve, I think the issue that you're hearing being hashed back and forth is this a prior non-conforming use which continues to run with the property? Or is the board prepared instead to grant a variance to the applicant to continue his business, which the applicant has represented he wants to continue for a maximum of 10 years? I guess he might stop sooner than that, I guess, if he retired or if he moved away from the site. But so I think
I have a question. I think I heard that currently it's just the applicant and somebody on a part-time basis?
that was his testimony.
Okay, so when was the last time there was more than that? Because the way he described it now, it sounds like a home occupation. Not that I'm
It's,
familiar with the parameters. And the question is, if you deny him the right, then it's like you're punishing him for past behavior that was unchecked.
we're
And I-
not, Mr. Stein, excuse me, I think,
Yeah.
there's a way forward, and I think our attorney is providing us with that guidance. I don't think it would qualify now as a home occupation in any stretch of the imagination. He's not sewing, he's not making hats, he's not doing it on 20% of the FAR of the interior of the house. So I mean, I respect Mr. Schatzman's argument, but I don't think we need to keep discussing this. There's a path forward. If the board is agreeable to that, then they should consider that, and then we can look at the other issues that are still to be decided.
I agree with that. That makes sense.
Get rid of it, you get rid of it. I mean, it's debatable. I mean, you know, debatable. It's not out of the question. As I said, Mr. Lanning's, now deceased, has a home occupation in Montgomery on 518. They consider it a five. I didn't have to go for variance for Mr. Lanning. He's a plumber. Now deceased, his son is taking over, but it's irrelevant. Under the Jantush case, if this person who gave the permission, of course, that person's not here either, whoever he or she is, and it continues on for so long a time, there's a doctrine of estoppel. And estoppel says you can't, if you wait that long, and it's a heavier burden, admittedly on the Jantuch case, it's a heavier burden to prove that there's an estoppel by a municipality as to a regular guy. So what I'm saying is, under the Jantuch case, it's gone on for so long. I cited the ordinance. Mr. Bridger doesn't think the ordinance would allow plumbing business there. But as I said before, it's irrelevant. As long as someone had some color, and you got to read Judge Fritz's case and the Howling case, and it continues on, the municipality can't stop someone from doing what he's doing there as a use. And that's the law. You know, that's my interpretation of the law.
Fine. Mr. Chairman,
Yes,
if the board doesn't have any more questions, I don't know if you want to open it up to the public.
Mr.
Well,
Chairman, I did have one other question, if I
go
may.
ahead.
So Mr. Schatzman is proposing as an alternative, a potential alternative for the business use of a 10-year duration after, and that would be for the first floor of the garage structure. After that 10 years, what would that use turn to? What would that garage space be occupied by?
But it just would be an empty storage area. I don't know that there would be any plans for it.
It would just be a garage.
It'd just
Yeah,
be,
yeah,
If- if-
stairs, lawnmowers, it's like a lot of people. A lot of people don't use garages for garages. They use it for storage. They want to pay a self-storage facility.
Okay, and the garage then would be used by the question I'm getting at is essentially there's a second principal dwelling variance that we're looking at here, and then is that garage space then after 10 years going to be considered part of the second principal dwelling, or is that garage space going to be used for?
That's
The-
second principal dwelling. The 347 already has a garage, doesn't it?
yes.
347, the other already has a garage. They don't need another garage.
Okay, so then that floor area would jump from 1,000 square feet to 1,200 square feet, and now could be possibly 2,400 square feet.
Well, it's living area. It's not, garage is a garage.
Okay, thank you.
And any other questions, board members?
Yeah, I want to understand. So we have no permit from 70 some years ago.
Right.
We just have hearsay that says there was a permit. Is
Correct.
that right?
Not hearsay. That's not hearsay.
Okay,
You
thank
know,
you.
Okay,
Person under the evidence rules of the state of New Jersey, if the person is unavailable, testimony can, if you believe it, testimony of an applicant, of a person, what somebody told him is admissible in evidence. You have to have what they call a 401 hearing, evidentiary hearing. It's an exception to the hearsay rule, okay? And even though under 40:55D-10E, technical rules of evidence don't apply to a land use board, yet if we were in court, that could be admitted as evidence. Mr. Keller Jr. said that his father on May 28th, his father told him he had a permit to operate the business. Then I got an email, this is what we're talking about now, saying from Mr. Wiseman and Mr. Bridger, do you have anything else to bolster that testimony? And I said, yes, so I'll ask my client. So I did. And you saw that as A2, as all of the permits. He's been conducting it. And the question there was the length. But because Mr. Senior is now deceased, Mr. Bridger can, I'm sorry, Mr. Keller Jr. can testify as to what his father told him. Are you familiar with that evidence rule, Ms. Casey, or not? It's the dying declaration rule that you learn in evidence, okay? That
Okay,
was expanded in New Jersey.
Mr. Schatzman,
That's the hearsay
I-
rule.
sir, do you want this hearing to continue or not? All right, we're
Well,
trying
yeah,
to move.
He made a statement that it's hearsay, and I'm saying it's not a hearsay.
okay,
well,
so
you know what?
let's
You and,
let's move on.
I'm making a record, okay?
that's fine. Make a record.
All right,
Go
fine.
ahead.
Thank you very much.
You're welcome.
Okay. All right, board members, any other questions?
Yeah, I have a question, Steve.
Certainly.
And it's a follow-up on the question about the secondary dwelling. 10 years from now, when, or less, when the garage space becomes available, is that then incorporated, could that turn into now a bigger secondary dwelling? Because right now, if I'm approving a secondary dwelling, I'm thinking a 1,200 square foot dwelling. If it's possibly going to turn into a bigger secondary dwelling, then I have additional thought to put in it. So I want to, are we limiting to 1,200 square feet? Or 10 years down the road, can it then become a pretty good sized house at you know.
Well, I believe, and correct me if I'm wrong, if the applicant, if the owner chose to do that, he'd have to come back to the board for that permission.
Well, Karen, do you believe, or Derek,
I had a couple questions, Michael. I'm glad you brought that up.
Michael,
thank you.
we can't see you. Can you put the, your video back?
oh, just a second,
Okay,
wait
Okay,
a minute.
Got your desk. Looks like.
yeah, we have a picture, we
Like
see your desk.
your folder.
Wait a minute, wait a minute, wait a minute, wait a minute. So you don't know what I did. Just a second. I don't know.
There
There
you
it is.
go.
Yeah, there we go, sorry.
Great.
So, okay, Derek, so if you had some of the same related or same field questions,
Thank you.
that's a big question for me.
It was kind of long that Dan started the line of questioning. and
Yes.
I think we heard that there would be 1,200 square foot apartment upstairs, which seems to be the full upper floor. Is that correct, Mr. Keller?
Yes.
So, I mean, the board could condition that space to just remain residential and the bottom remain as it is today, which it's a
That's-
garage.
That's fine.
That's
There's no
fine.
intent to create the bottom into living space.
Yeah, I got a couple more questions. I appreciate that. And I don't know if you're aware, but the building code requires separate utilities for another dwelling on the property. So,
We agreed to that on May 28th.
okay, all right. But the board could, if you're agreeable, impose a condition on the size of the apartment and that the bottom remain as whatever you propose, storage, garage space.
That's fine.
Okay, thank you.
Thanks, sir.
Good. Okay, any other questions from the board? Okay, I'm going to open the meeting up to the public. Claudia, is there anyone in the audience who's indicated they'd like to speak on this application? Claudia?
I'm moving them over 1 second, please.
Okay, thank you.
Mr. Barr, are you there?
Sorry, yes, I am. Can you hear me now?
Yes, we can.
Sir, could you give us your full name, please?
Yes, my name is Christopher Barr.
All right, Mr. Barr. I don't remember if you testified at the last hearing, so I'll just swear you in. Do you swear or affirm your testimony this evening will be truthful?
Yes, I do.
And Mr. Barr, if I remember right, are you an officer of the Ridgeview Conservancy? Is that correct?
Yes, I am. I'm the executive director.
Okay, thank you.
Our director of stewardship, Patricia Shanley, and I submitted a letter concerning this application earlier today, and our understanding was that it was shared with the attorneys and with the town staff and made available to the members of the zoning board. May I read the letter into the record?
Yes,
Yes.
please.
Go ahead.
Okay, dear Mr. Cohen and members of the zoning board, we are writing in our respective capacities as executive director and director of stewardship of Ridgeview Conservancy, a 501c3 land conservancy based at 211 Ridgeview Road in Princeton. Our organization's mission is 1, to restore connections to nature by educating youth and the public; 2, to conserve vulnerable forests, wetlands, and cultural historic sites; and 3, to promote equitable access to nature for underserved communities in and around the Princeton area. Since the May 28th meeting of the zoning board, our organization has been in discussions with the applicants Patricia Keller and her brother Gene Keller Jr. Concerning the possibility of establishing a conservation and trail easement on a portion of their property at 371 Ridgeview Road. So this is block 401, lot 14. And we're very pleased to report that Ridgeview Conservancy and the Keller family have now reached an agreement whereby our organization will purchase a conservation easement covering an area of approximately 4 acres in the heavily wooded portion of the northern half of the parcel, together with a 12-foot wide easement for a public walking trail along the western border of the property from the conserved area to Ridgeview Road. In agreeing to partner with Ridgeview Conservancy in establishing this conservation and trail easement, the Keller family has chosen to make a very considerable contribution to the Princeton community, the benefits of which will resonate for generations to come. In recognition of this contribution, we urge the zoning board to approve the Keller family's application, subject to the condition that the conservation and trail easement be recorded with the deed prior to the future sale of the subdivided property. The conservation in perpetuity of the northern portion of this parcel and the creation of a public walking trail on the Keller property are important for the following reasons, and I'll just go through these briefly. One, priority habitat for conservation. The property is located on the northern slope of the Princeton Ridge, an environmentally sensitive area with a basalt diabase substrate and large rock formations composed of diabase boulders. The planned conservation easement contains closed canopy upland forest, early successional habitat, and deciduous wooded wetlands. A freshwater spring is also located on the northern boundary of the easement area, which flows into Cherry Run, a tributary to Beedens Brook, a Category 1 stream. Virtually all of the planned conservation area has been classified as either medium high priority or high priority ecosystem to protect on New Jersey's conservation blueprint. The easement area has been documented to provide suitable habitat for numerous species designated as endangered, threatened, and/or of special concern in New Jersey, including the red-shouldered hawk, barred owl, wood turtle, and New Jersey bobcat. Secondly, it's important for its cultural historical significance. The Keller property is located in a section of the Princeton Ridge that is associated with several layers of remarkable history. Most directly, the writer Upton Sinclair lived in a tar paper shack in the woods on a neighboring parcel when he wrote his first novel, Manassas, and began working on The Jungle in the early 1900s. It is recorded that Sinclair and his family used the spring situated on the northern tip of the planned easement to bathe, cook, and wash their clothes. Read by President Theodore Roosevelt, publication of The Jungle in 1906 led to the establishment of the Food and Drug Administration, the FDA. More generally, the ancestors of the Lenni Lenape are known to have lived and hunted in the forest along Cherry Run, and Paul Tulane, the founder of Tulane University, owned a 500-acre farmstead which spanned the corners of Cherry Valley and the Great Road. The presence of these sites presents outstanding opportunities for place-based education about highly significant yet largely unknown elements of Princeton's history. And finally, connectivity to preserved open space. The planned conservation and trail easement is contiguous with conservation trail easements that extend across 3 neighboring parcels and is situated within 500 feet of 28 acres of conserved open space on no fewer than 5 other properties. Collectively, these existing tracts of open space were funded by donations from Princeton's Open Space Trust Fund, Mercer County's Open Space Preservation Assistance Program, and NJDEP's Green Acres Program, as well as private donations from members of the Princeton community. Conservation of the Keller property and the creation of public trails will significantly extend and enhance the considerable investments that have already been made in this ecologically significant and historically rich part of the municipality. We respectfully request that the zoning board take into consideration the very significant public benefits associated with the Keller's agreement to create a conservation and trail easement in partnership with Ridgeview Conservancy. Conservation of this critical link of Princeton's Emerald Necklace is an extraordinarily generous gift on the part of the Keller family, which will honor both the ecological and historic significance of the site and their family's 80-year stewardship of this important property. We hope that the creation of this conservation and trail easement can be incorporated as a condition into the zoning board's approval of the Keller's present application. Thank you very much for your consideration and support. And again, this is from myself as Executive Director of Ridgeview Conservancy and Patricia Shanley, the Director of Stewardship. Thank you very much, and I'm pleased to answer any questions.
Board members, any questions?
I have a statement.
Go ahead.
We agree with Mr. Shanley that we're going to give an easement, but he was kind enough to send me what he was going to read into the record tonight. However, since there's no rational nexus between what we're asking for and assuming you grant approval, we can't have it as a condition of the zoning board. He'll have to rely on a representation. This is because of two cases that were decided by the appellate division called Nunziato versus Edgewater and Marlborough versus Homedale. Those cases say that if a planning or zoning board conditioned approval on something that has basically no connection to what the applicant is asking for, and the application is that anything like this would be considered for using a very euphemistic word, a bribery to the board to grant the variance. While you must consider, and I'm sure Ms. Casey will have her opinion on it, you must consider the merits of the case that we presented. And again, just so you know, we agree to give them an easement. We think it's a nice addition to the property, but you cannot consider it. It's like a judge giving cautionary jury instructions to a jury, and you cannot condition it because of the Nunziato case and the Marlborough case. You want to comment on that, Ms. Casey, please?
I'm happy to come.
Mr. Schmidt, I'd actually like to comment on it because it seems to me that this has been a situation with a history of not complying with things. And so I would think it would actually be to your benefit not to say no to something like this and assume that we would think that you would go ahead and honor the commitment without it being, I don't know that we haven't gotten there yet, whether or not that would be a condition of this, but it just strikes me odd that you would say no to it. You would find a way away from it right now.
Why don't we
Ms.
get an
Coulson?
opinion from Ms. Casey?
Yes, yeah, if I could interject here. If the reason that we can't make it part of this application is because it has no relationship to the relief that's being sought. It was not part of the application. Since it's not part of the application, of course, the applicant didn't notice for it. And nor has the trails or anything been reviewed by the town open space coordinator, which I believe would be the normal process here, get that input as well. So I agree with Mr. Schatzman that it would be inappropriate to make this a condition. It is not related in any way to this application. So Mr. Barr, he's read it into the record. The applicant has indicated they will do it. That's, that will have to be up to you and the other board members, whether you take this into account or you don't, but it doesn't have a relationship to the relief that they're seeking. You have to judge, you got to judge that application on its own merits. So.
If I may, I'd just like to reiterate our thanks to the Keller family, as well as to Mr. Schatzman for confirming that they would like to move ahead and create a conservation and trail easement in partnership with Ridgeview Conservancy on their property. We're extremely grateful.
Thank you.
Yes.
Okay, Karen, do you have anything you want to add?
Excuse me, just so you know, what will happen is somebody could void the total approval.
All right, let's, Richard, please allow us to continue. Okay, Karen, do you have anything to add?
No, I guess I don't know if there's any more public comment.
I'll ask Claudia, anyone?
There are no more hands.
Okay. All right, so we'll close the public portion of the hearing. Mr. Schatzman, can you sum up? Would you like to sum up before we go into executive session?
I summed up when I said, I think if you granted a use variance, we would discontinue a non-conforming use, which is a goal of planning, any planning board or zoning board. You get 2 conforming lots in the RA and RB district. You get rid of a non-conforming use in the 355, which is 3-family dwelling. You have 1 lot on each of the, 1 house on each of the lots. You have you give Mr. Keller Jr. a right to live on a suitable apartment, albeit a single-family dwelling, with conditions that you want to ensure that everything is carried out. Your guarantees are that the subdivision plans won't be signed until everything is done. You have you have performance bonds for the demolition of the houses on lot 14. And when the deeds that are used to perfect the subdivision will have, I can work out with Miss Casey, restrictions so that somebody buying, whenever that happens, the property knows what the terms of this variance, should you grant the variance, are. Actually, you don't have to do that under a case called Aldridge versus Schwartz, which said that a person buying a piece of property where there was a variance should go to the zoning officer's file or the zoning file in the municipality and check for themselves. And in that case, a man bought a lot down the shore with a setback line in the variance that was granted for the lot from the beach. And when he built the house was over the setback line. And he said, I didn't know anything about it. It's not in the, it's not in the chain of title. And Judge Cohn, speaking for the appellate division, said, you should go to the zoning officer or the zoning office in that municipality, and you should have checked it out. And he said, notwithstanding the fact it wasn't recorded as in the chain of title, okay, you're still responsible. I don't think that, even though Judge Cohn is a very smart lawyer and a smart appellate division judge, I don't think that protects the town too much. So what my suggestion is, as a condition, helping you out, should you grant the variance, we put wording in the subdivision deeds so that a person buying the property knows that there are certain conditions, i.e., it's no more than 1,200 feet, i.e., that the garage can be only used for storage, i.e., the business of Mr., should he sell it before, the business of Mr. Keller Jr. terminates within 10 years, and all the other restrictions, depending upon what the resolution memorialization would say, would be right in the chain of title. So no one can complain that they didn't know anything about what the variance was. And that's what I propose as a condition to protect the town, even though under Aldridge versus Schwartz, you don't have to do that. And that's my summary.
Okay, thank you. All right, board members, you've heard everything. You've heard Mr. Schatzman's summation. You've heard from the Conservancy. Again, it doesn't have any legal bearing on this, but you've heard from them. Let's discuss this and come to a vote. Comments, questions, motions? Okay, I think quite. Did somebody say something? I'll wait.
No, go ahead.
Yeah, I think it's a very reasonable request. The fact that he's going to basically limit the operation of the business for 10 years is good. I think Mr. Schatzman's last comments with all the conditions in there should be incorporated into any motion if we choose to go forward with this. And I think it's a very reasonable request.
I agree. Likewise.
I do have a couple questions, Derek, Karen, just to make sure I understand this correctly. And I think Mr. Shaxman had opined to it, proposed it, whatever, that the subdivision can't be perfected until, 371, 369, and 355 are dealt with by the applicant itself. It's no longer the possibility of any of that being left to the eventual purchaser of 14. So did I hear that correct? That it's really related to, will be tied with the perfection of the subdivision, if assuming we approve that? Yes? Yeah, that helped me a lot because I didn't want anything to possibly go to, especially with 355, to the potential buyer. So I think they've agreed to that. That's, I believe, great. The time frame is short. I do believe then, on 14, I'm fine with it. And now coming on 13, so we're no longer trying to fit it under accessory dwelling. It's now just a secondary primary residence or dwelling unit. So if it's limited to 1,200 square feet, that's fine. That helps too. So those are the two big hurdles, I thought.
I
You know,
have,
the
no, I'm
others,
sorry. Go on, Michael.
yeah, the other side variances, whether it be for the storage units or whatnot, I think seeing where they're located and they're adjacent to woodland as opposed to houses, I think that's fine. Or I can accept that in the setback. Go ahead, Karen. I think I'm.
Okay, here was my question. What is the board's, I would like the board or somebody to articulate for the board what criteria you think they've met for allowing a secondary dwelling unit. I ask that mainly because I'm going to be preparing the resolution, but I think it's important to be able to articulate what it is about this situation factually that would lead you to approve it, so that in future cases, we can look at the resolution and say, well, here's what happened on those facts. But in another situation, it's not a given that the board is again going to say, sure, you can have a secondary dwelling unit.
I was gonna, oh, sorry.
Mr. McDonough testified on May 28th.
Whoa.
No, well, okay, the board's in executive session now, Mr. Shatzman, and also Mr. McDonough, his testimony was that, it's a minimal increase over what's allowed by an ADU. That was what he testified. So I didn't mean to interrupt you, Michael.
Could I ask a question? As my understanding that one of the main parts of this thing is that they're going to reduce existing nonconformities.
Correct.
And I'm wondering if that weighs in favor of permitting what would be the 1,200 square foot secondary dwelling, also a nonconformity, but it's within a context of a much larger reduction.
I think it could be. I think that's, in this case, I don't think we can consider any of these things hardship situations. We are talking about other criteria, which is for a use variance, it's what's called special reasons. So we would always, we might look at the purposes of zoning, what is being accomplished here, what are positive things that will come out of this application. So I think certainly that could be a factor, absolutely. But that's why I want the board to articulate it so that, ADUs are a very popular thing, and the square footage, of course, is tied to what you're allowed to do under the ordinance. So if you deviate and the board feels that it should be allowed, then just have to explain why.
Thank you.
So, for me, I think what distinguishes this from the previous case we heard where it was, the applicant was asking for a second principal dwelling, it's the size of this property, the size of this lot, and where it is in town it's a quite different situation, and they're dealing with an existing building. I am a bit confused as to how we're getting to 1,200 square feet. Maybe I'm missing something, but when I see the survey and the garage at 28.6 feet by 30.5, is that correct? Yeah, I don't get close to 1,200 square feet. I get under 900. Am I missing something there?
I'm sorry, what were the dimensions that you had again?
I'm looking at the survey. It's 28.6 by 30.5.
No, it's wider than 30.5.
The
Okay,
survey is wrong.
Well, I don't know. I don't have a copy of that in front of me, but the building is going across as the width of 4 garage doors.
okay. Do you want to pull up that?
Yeah, that'd be a
survey?
good idea.
Yeah.
I'm coming up with 52 by lengthwise, approximately. It's at a 50 scale, so it's hard to tell. 52 or 53 in length by
That would be correct.
Oh, okay.
like 32 or 33 in width.
Yeah, which would be more than
So-
1,200, but and
Okay.
you're scaling it, so, you're trying to scale off a small drawing, so it's difficult.
And I believe that second floor has a sloped roof, so a portion of that may be under the 5-foot threshold
Good
for
call.
calculation of floor area.
Okay,
It
so
is
that's
there, and there's a knee wall there at that
uh-huh.
5-foot threshold, and that's where we got the calculation from.
Okay.
All right. That satisfy your
Yes,
question?
yes,
Donna? Good,
yeah.
Thank you. Okay, any other board members have anything they want to add, or does someone want to, bring this to a close and make a motion?
I just have one more clarification. The removal of the storage units, I believe that's something that staff raised. Is the board saying that they don't feel they need to be removed or moved?
Board members? Michael indicated he felt they were acceptable.
Staff have any comments on this?
Just a question on that for Mr. Floyd or just in general. Would that be along with the 10-year, or actually, let me step back. It's unclear if those are related necessarily to the business. Would you, within that motion, then say those can stay for 10 years with the business? Or are those more of for the residential properties?
Those are more for the residential property.
Understood. Thanks.
Well, I would, I hadn't thought about it that far. It probably did cross my mind a little bit. Could they be moved? When might they be moved? If they could they be moved right now? But with the 10 years from now, that just got proposed of vacating of the garage space and finding a new use for that. That could be a spot for it, but
Certainly that's possible.
Just for clarification, then I'm looking at the staff comments in the review memo prepared by Mr. Weissman and Mr. Bridger. And they note there's an approximate 20 by 40-foot area between the storage containers and a detached garage on lot 13 that contains water heaters, furnaces, and appliances. There is also possible staging of construction materials and work vehicles. So this comment was put in the context of raising the question of the business use of the property. So I'm just trying to clarify, does that mean that they can keep the water heaters, furnaces, and appliances? I guess they're stored outside, if I understand the comment correctly.
Well, things like that are there for a short period of time. They're no longer there. So when there's a load to be taken up to the scrapyard, then that's when they're relocated and taken up. So I would say that it's dramatically different than what it was at that time because the things have been relocated. We recycle it to scrap and it's been, and all that has been relocated. So as things are taken out, they get collected there on the side. And then when there's enough to put in the truck to take a load up, we take a load up and get rid of it. I don't know if that answers the question.
Well, when you terminate the business, then there whatever's left there will get removed.
Oh, absolutely. And it gets removed periodically. I mean, there's nothing there right now to take up to relocate. So, I mean, it's all clear.
Okay.
And just to remind the board, 10 years from now, when the business is removed from that first floor, there will be storage space within that first floor for the residential properties.
Absolutely.
Okay, board members?
I would move for the acceptance, except I don't think I can articulate all the bits and pieces.
Karen, can you,
We'll give it a try. All right. So if it's a motion to approve, the motion could state that you're approving the minor subdivision application, that you are granting a use variance for the plumbing business to continue for a maximum of 10 years, I guess from the date of the publication of the memorialization of this approval, that during that time period, as long as Mr. Keller actively operates and owns the plumbing business and resides at the property, he can continue to run his business there. The operations as he described them with a part-time employee, and I think he has one vehicle that he uses, those conditions would also be conditions of the variance. He will convert 355 Ridgeview to a single-family home. This would need to be done before perfection of the subdivision deed or plan, whichever way they proceed. I do have a question about, there was an agreement to bond for the demolition, but are you looking to have the demolition done before the subdivision is perfected? Because ordinarily the bonding would be to make sure that's done. So I'm not clear on what the board, what their preference was on that.
I got the impression that that would be done prior to the, once people move out, that work would be done right away.
All right, so then the bonding,
yeah, that's what I heard too.
okay. So is the bonding, I'm gonna ask staff, do you feel you still need bonding if all this is, needs to be done before perfection of the subdivision?
What if the subdivision's not perfected? What if something happens?
True. Good point. All
And I
righty,
hate, and
so,
I hate to bring up one more issue, but I
Yep.
think it's prudent. Can these two houses be sold separately on the lot where the second principal dwelling is being created? We're gonna say that the apartment has to stay upstairs and that the bottom of the garage has to remain storage.
correct,
But
but,
some future, the question may come up in the future, can that house be sold separately as a condominium?
oh, I don't think we have any control over creation of condominiums.
No.
Okay,
So I don't, I
Good.
mean, I think the
All
answer to that is yes. If Mr. Keller or a future owner wanted to turn these into condos, they could.
thank you.
Okay. So
Going
I'm
back to
continuing-
the first
Yeah.
question though, Karen.
Yeah.
So if everything needs to be done before the deed or plat is
Right.
filed, that needs to be done within 190 days.
Right.
And Mr. Schatzman mentioned the possibility of an extension. But
Right.
as we know full well, because we have 4 minor subdivision extension requests on the planning board meeting tomorrow night, an extension can only be granted if basically something delays, a government entity delays the applicant from being able to file their plat. So there is a very real possibility that the demo of 2 houses, the conversion of the third multifamily to single family does not occur within 190 days. And then the applicant, would basically have to come back to the board and request this all over again, or request an extension, but prove how a government held
Right.
it up. I think with the bond option, there is not necessarily that timeline. The timeline comes down to, how long the applicant is willing to stay without their money. So it seems like it would be in a better interest, or at least those are the options. I'm not going to say what the better interest is, but one's about time and the other's about money. And one very well might give more flexibility than the other. So, I don't know how the board feels about that. We heard how Mr. Schatzman felt about doing it for the subdivision earlier, but I'll just leave the board with that.
Aaron, your
Board
opinion?
members, what's your thought?
My thought
Well-
is that if the bond option, that would give the applicant the couple of months time, or longer than a couple of months to get this all done. And that seems like that probably would lead, if the end goal is this result, I think that would lead to, there's a higher likelihood that would lead to what we've spent 2 meetings talking about.
But Justin, you're talking about the town calling in the bond? When you're saying it would give the applicant more flexibility? Well,
More time, essentially.
why?
Because then they don't have 190 days to finish the work. They basically put up the bond, and then if it takes them 6 months, if they could live without their money for 6 months, then they would be able to do that.
Okay, but
Or
let
2
me-
years, or
Okay, but let me just, let's go through what the scenario that you propose. So 190 days comes and goes. I don't know, tenants didn't get out right away, whatever it is. And now the applicant is back in front of the board and said, I couldn't get it done in 190 days. But there is a bond. So are you saying that the board would say, that's okay, we're gonna call your bond in. We'll get them demolished using your money. And, okay, we'll sign off on your plat or your deed. Because
I
we,
was
you know,
taking
the bond doesn't help unless we call in the bond,
Mhm.
right?
Yeah.
We need, there's an affirmative action we have to take for something to happen. So calling in the bond, and of course, with bonds, I mean, bonding companies are not, they're not quick ordinarily to honor their bonds. So, so if the applicant is, so that's why we talked about bonding for the demolition of 369 and 371, but not for the conversion of 355 to a single-family home. Mr. Keller Jr. said he didn't think that was going to be, very complicated to convert it back to single-family, as long as his tenants, vacate. So what, Justin, so what you're thinking though was that then if a bond is in place, the board could just go ahead and perfect the subdivision and go ahead and call on the bond.
I thought, and I could be incorrect here, was that the
Right.
applicant would still be able to file the deed or the plat, sign off on that, and then similar to kind of a performance bond that we have,
Right.
that would exist separately,
Right.
where ultimately, it's on the applicant in their best interest to do the work so they get their funding back. I think of them as
Okay.
kind of two separate items.
Right. So then so the idea being that they've bonded, or they will have to bond for 369 and 371 demolition. And as long as they've done that, then that would not be, if it has not been removed and they're closing in on 190 days, it could still be signed off the deed or plat because a bond is in place. Now, the conversion of 355 to the single family, are you thinking that there should be bonding for that too, or?
I don't understand why we would do one way and one another. I mean, if there's a reason why not, why, from the applicant's perspective, why we would do them separately. I'd be open to hear it, but it seems like it's basically kind of an all or nothing thing to get to what we've described as ultimately, one home on that lot.
You can't
Board
get,
members, does that sound okay to you?
no,
I
no,
think,
because one is, let me speak, please. One is a demolition. One bond is a demolition of two houses. The other is renovating a house. You can't get a bond to renovate a house. You can't get a performance bond to renovate a house. You get a performance bond for demolition. You can't get a performance bond to demo a house. I mean, to redo a house. They're two different
Sure,
things.
that's
You're talking
true.
about oranges, you're talking about oranges and apples. That's what the difference is. He said he could take care of 355 right away.
Okay, so we'll
Bond for
leave it,
that.
Sure.
all right. We'll leave it at that. Yes, Michael?
I mean, I do see the argument, and I don't mean argument, but the reason to have some kind of leverage on 355. I mean, even though I know the applicant's attorney, the board, we're all headed in the same direction and we're close here. But I'd say 355 being a 3-unit building that was never approved is actually one of the major violations. And it should get done. I believe he will do it. I thought of it earlier, but suggest that now that we're back talking about this, that you might consider, and I'm speaking basically of the municipality, issue a violation to him now.
Well,
Get
what
it
I
on
was
the
gonna
record.
say is we could condition this whole thing on, if he doesn't perfect this subdivision, then a violation will be issued and he'll have to either go to court or come back here, I mean, it's kind of like deja vu all over again, but.
Yeah, I think some kind of violation at some point.
No, but that would be that's what I was thinking. If they don't do everything they said, then they're in violation. They're in violation now, and they're trying to be proactive and correct this and clean it up. And I take them at their word, but we still have enforcement issues that we can go after them.
Yes.
There'll be a non-complying, business. The subdivision won't be perfected. So, and you got to hit all those compliance factors to make this a compliant application in the subdivision to go forward. So, I mean, we do have some tools. in our, you know, toolbox to address it.
And yeah, that's good to hear. And I think the board should care.
Yeah, and I agree.
I agree too.
Okay, so
Well-
what, so bond for demolition of 369 and 371 and the conversion of 355 Ridgeview to a single family. That has to be done before, well, all these things, the bond has to be posted and that has to be done before the deed is perfected or the plat is signed. And if it's 190 days and they haven't done it, then unless they have a reason why governmental entity stopped them from moving ahead, then they will be issued notices of violation. Is that an accurate summary?
Derek?
Yes.
Yes.
Okay, all right, and then continuing with conditions, the applicant will deed restrict the,
Miss Casey, I'm sorry.
Yeah.
I just,
sorry, that's okay, Dan.
so with the demolition of the two single-family structures, not being completed prior to the perfection of the subdivision, I do believe that a temporary D2 variance is required, because that would be the intensification of the non-conforming use. And that would be temporary contingent on the demolition bonds.
I guess the question I had on that, do we have to grant those variances?
Right.
They just, you know, between now and the next 90 days, they're without cover on that. I don't support granting variances for that, temporary variances or whatever.
Dan, I guess, Dan, the concern is I understand your position, but then if they've already gotten variances for it.
Yeah,
If notices of violation are issued,
Have a variance.
all you would do is tell the judge, but it's allowed.
yeah.
I got approval for this. Yeah, I'm working on getting them demolished, but I have approval. They said I could. So
don't think we should.
And
I think that's gonna take, I mean, if you're trying to decide this as a municipal judge, you say, is that true? That they have temporary approval? Oh, well, okay.
Do that.
But Mr. Schatzman, is your team prepared to demolish those two houses within 190 days of the resolution of this approval? I don't know if I heard that.
Yes, actually, when we got the notice from Mr. Bridger about the house that was supposed to come down in 1974, we reached out to two demo companies then at that point. And then they said that they would the demo companies would provide the performance bond to go with the demolition. At that time, we were not thinking that 369 would have to come down immediately because it's currently a permitted use due to a previous variance. But we had made arrangements that as soon as the tenants were out, that the 371 would come down. And if a bond needed to be provided at that time or before then, that was going to be done. So we're willing to move forward on that. We're a little surprised about having to take down 369 at the same time, but we'll find a way to work around that. So we want this whole thing to move forward. We don't, not that we don't like you guys, but we really don't want to be seeing you guys next month like this again. I don't know if that makes sense.
So you will take both structures now.
Yeah, they already agreed to that. Yeah.
Okay, fine.
Okay. So then moving on with conditions, the applicant agrees to deed restrict the size of the secondary dwelling unit on the second floor of the garage, not to exceed 1,200 square feet. They'll also agree to deed restrict the use of the first floor garage during the period of operation of the business that can be used for storage, correct?
Yes.
Yes, all right. And that once that business, that variance has terminated, then the garage can only be used for, as a residential garage.
Or storage, residential storage.
All right, yeah. Okay,
Karen, would it make more
Yep.
sense to say something like the habitable space on the second floor because we don't know the exact square footage of it?
If we could
Okay.
say that we could limit it to the existing second floor space of the garage,
Yes.
existing
Oh.
habitable floor space of the second floor of the garage.
okay. Not to exceed 1,200, or you're saying if it's more than that, that's okay?
Yeah, I think we don't know right now what it actually is.
Okay, so. All right, so you're not approving it for any particular square footage, you're saying whatever the existing habitable floor space is?
Yeah,
Yes.
the second floor footprint, say, maybe.
Well, but
Yeah.
there's knee walls in there. It should be, you know, habitable
Habitable,
is
okay.
defined.
Okay. And then lastly, I believe at the last hearing, the applicant's witnesses said they would comply with the comments in Mr. Bridger and Mr. Weissman's review memo. And I think that's what I've got.
Steven, does that sound reasonable?
Steve, who did you ask that of? I couldn't
I
hear.
asked that, Stephen made the motion, right?
Yeah, I would have said it just like that.
Very good. Okay, do we have
So
a,
I move that we accept the proposal.
okay, do we have a second for that?
I'll second Stein.
I have a
Okay.
question. If I may ask a question though, are we being,
Sure.
I think this is a follow-up to Bernice. Maybe you got the answer and I missed it somehow, but are we being asked to approve 2 primary dwellings in a single
Yes.
family zone?
Yep, correct.
Yes.
That's what you're being asked to approve.
Why? I just want a little help with that. Why?
Well, because the applicant, remember
it-
that with ADU, the size, the square footage of it is tied to the size of the single family home that it's accessory to. In this case, that means they couldn't have more than approximately 800 square feet. But the
Right.
applicant wants more than that. And
Well,
Discussion about the length of time that the property had been in the business use, the size of the lot. Bernice discussed that, as Karen had asked for reasons.
right,
Why, you know, how do I?
And existing structure.
Yeah,
Yeah, I think the
Well-
difference in this existing structure versus the other one I was referring to where we were asked to consider a second primary residence. This one, we're looking at, say, the whole habitable part of an entire story, and it's a larger, but it's a much larger lot, and the other case had 2 levels that they were trying to capture, one of which they were able to exclude. I think the particularities about this existing structure and this size of this lot and where it is in town makes it acceptable in this case.
the fact that it's already there is key. Is that?
well,
Well, we looked at one that was already
Already there, yeah.
before, yeah, but that existing structure had different they were trying to capture part of the first level and the second level, and this one it's all one level, and I think the question would be the question that was raised was, how are you going to exclude some 200 feet of that second floor, and and know that never gets somehow absorbed into the habitable space.
and another difference is the other property that we looked at in a similar case did not meet the setback. And if you look at the setback on this property, it's the house is, or the garage is 50 feet from the rear yard setback, which will be even increased when they do the subdivision. And it's 64 from the nearest side yard. So the
Yeah.
other one was less than the 15-foot required setback. So there's a few differences.
Are you okay with that?
Maybe this will lead to more dual primary dwellings in single-family neighborhoods. That'd be great. Anyway, that's,
That's an aside.
yes, that is an aside.
Yeah, never mind.
No, go ahead, Michael, if you'd like.
No.
Can I call the question?
Yeah,
Yes. Okay, so we have a motion, we have a second. Do we have any other comments? Okay, Claudia, can you call the roll, please?
Ms. Chen,
Yes.
Ms. Coulson,
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Mr. Tenema,
Yes.
Mr. Stein,
Yes.
Chairman Cohen.
Yes.
Thank
And just as not part of the record, I'd just like to say to Mr. Keller, I think you're making a valuable contribution to the Conservancy. And I think the community appreciates that.
Thank you for your comments, sir.
Okay, so we did it. There's nothing else on the agenda this evening. And so we'll adjourn until next Wednesday to our next meeting. Thank you all.
Go
Thank
ahead,
you.
Ron.
good night.
Thanks. Good night.
Thanks,
Bye.
everyone. Take care.